Hello, my friends, and welcome to the Personal Responsibility Lawyer Podcast. I'm your host, Michael Lovins of the law firm Lovins Trosclair. Most of us know the Federalist Papers or know about them. They were written by James Madison and John Jay, and in the last couple of years, a remarkable number of people know that Alexander Hamilton wrote The Other 51, which is a reference to the Broadway musical Hamilton. And if you haven't heard of that, I invite you out from under the rock you've been living under. But today we're going to discuss the Anti-Federalist Papers, and my guest today is one of the leading experts on those Anti-Federalist Papers. My guest is Judge Andrew Oldham of the United States Court of Appeals for the Fifth Circuit. He went to the University of Virginia for college, then got a master's in philosophy from the University of Cambridge. Then he went to law school at this little place in Boston called Harvard, did a circuit court clerkship in Washington, D.C., and later a clerkship for Justice Samuel Alito on the U.S. Supreme Court. He's worked in the Department of Justice, Office of Legal Counsel under the George W. Bush administration, worked for the then Attorney General Greg Abbott in the Solicitor General's office, and then as General Counsel to then Governor Abbott, and still Governor Abbott, but he was governor at the time. And then he was one of the youngest ever to be appointed to the federal appellate bench here in the Fifth Circuit. And he was confirmed by the Senate in July 2018. Judge Oldham, welcome to the Personal Responsibility Lawyer.
Thank you. It's a pleasure to be here.
So, first of all, what exactly are the Anti-Federalist Papers?
Well, the Anti-Federalist Papers, unlike their Federalist counterparts, are not it's in some ways easiest to understand what they are by thinking first of what they're not. They're not a comprehensive, systematic, numbered or chronological response to the Constitution. They were drafted by lots of different people in lots of different places on lots of different themes. And importantly, they weren't collated the way that the Federalist was. And that has a lot of consequences. They had a lot of consequences in 1788 and 1787 and 1789 for that matter. It has consequences for us today because they're not organized the same way. There's not even universal agreement about what should be included in the work. And they're not, if you've ever sat down and read the Federalist from cover to cover, you realize that they're organized by article of the Constitution, by theme. They have a certain coherence to them. It reads like a book, whereas the Anti-Federalists don't necessarily have that same quality to them.
So we know who wrote the Federalist Papers, and it's just three people. Do we know who wrote the Anti-Federalist Papers, and to the extent we know, who were they?
So we do have some, but we don't know all. And in some ways, some of the most important questions about who wrote the Anti-Federalist Papers remain unanswered to this day. So one of my favorite Anti-Federalist authors is a woman from Massachusetts named Marcy Otis Warren, and she wrote an Anti-Federalist paper called A Columbian Patriot, which incidentally had been attributed erroneously to Elbridge Gerry, who, if memory serves, was the fourth or fifth vice president of the United States, also from Massachusetts, and had been attributed to him for many, many years until papers unearthed several decades ago finally attributed correctly to Marcy Otis Warren. And she's one of the few Anti-Federalist authors who has been credited by name in Supreme Court opinions. So in the U.S. term limits case versus Thornton, the Supreme Court in a footnote rightly credits Marcy Otis Warren as having written the paper A Columbian Patriot. But oddly, a lot of the others we don't know. So we have a general sense that Richard Henry Lee of Virginia had written some. We know that Melancton Smith wrote some. But big ones, Brutus and Cato, two of the most prominent, those are actually debated propositions about who wrote them.
So you referenced Brutus and Cato. So where do these – Brutus and Cato is obviously a pseudonym or pseudonyms. Any idea why they chose those pseudonyms? And, of course, the Federalists were all published under the pseudonym Publius, or I'm not sure if it's Publius or Publius. Where did they get those names to the extent we know? Why did they choose them?
Yeah, this is a fantastic insight into what the project was. That is what the Anti-Federalists and the Federalists were both trying to accomplish in writing their papers. So let's start with Brutus. Brutus was actually the first of the Roman consuls after the institution of the Roman Republic. If you know anything about Roman history, after the fall of the last Roman king, there was the Roman Republic was governed by a multi-member consulate, and one of the first was Brutus. Publius was actually second. So Brutus named himself first, and Publius was in some ways a response to the honorific that Brutus had adopted. It's interesting that people forget sometimes that the Anti-Federalist Papers, the first of the Anti-Federalist Papers, were published before the first of the Federalists. Obviously, when the Anti-Federalists first started writing, they didn't call themselves the Anti-Federalists.
Right.
They called themselves Sentinel, Brutus, Cato, and a lot of the names harken back to periods of the Roman Republic. And in those names, we see, I think, two different things. We see one, a fear of tyranny, because the whole premise of the Roman Republic was to sort of throw off the shackles of tyranny and to have a republic instead of its opposite. And two, we see defenders of so it's both throwing off the tyranny, but also defenders of Republican principles, little r Republican principles.
So what were their objections to the Constitution as originally drafted? And did they have – obviously they lost in some sense in that the Constitution was ratified. But what were their objections, and did they have any impact – did they make any gains in the opposition to ratification?
Well, so they certainly made very immediate, short-term, and obvious gains in the sense that the most widely accredited contribution of anti-federalist thought was the Bill of Rights. So one of the things that the Anti-Federalists were very upset about, and one of the themes that comes throughout their writing, it's in Sentinel's first letter, which, if memory serves, was the first of the Anti-Federalists by chronology, the first of the Anti-Federalist essays published, was where's the Bill of Rights? The people of the late 18th century expected to see their rights written down. There had been a well-worn institution that dates back to Magna Carta, the first English Bill of Rights of 1689, and the state constitutions did not uniformly have bills of rights, but many of them had bills of rights. Right. And so one that Sentinel points out is, what about the Commonwealth of Pennsylvania? The Commonwealth of Pennsylvania, in its constitution prior to the founding in 1789, or the framing of the Constitution in 1787, the Commonwealth of Pennsylvania had a Bill of Rights. And the theory, the Anti-Federalist theory, was if we don't write down the rights, how do we know that they are to be respected? How do we know that they won't over time be eroded? How do we know that the people won't, what will be the people's safeguard against the infringement of those rights without them written down somewhere? And so one of the principal things that the Anti-Federalists demanded throughout the founding period between September of 1787 and the ratification in 1789 was, we want our Bill of Rights. Please write these things down. And as a consequence, throughout the state ratification period, many states, Massachusetts is the most vivid example, but it's not the only one, in their ratification instruments adopted these anti-federalist ideas and said, here are our proposals for bills of rights. And so when the first things like the First Amendment, what we now call the First Amendment, and the Fourth Amendment, the jury trial right, things like that. So when the first Congress met in 1789, one of the first orders of business, obviously, was to propose our first 10 amendments to the Constitution, and that was a direct response to the calls from the Anti-Federalist and, depending on what historical materials you read, a fear that perhaps there would be a clamoring for another constitutional convention without the Bill of Rights.
Okay, so if I understand the history right, the response or the argument of the Madisonians, those who favored ratification, was, well, we don't need to write these rights down. We don't need a Bill of Rights because there's no power in the Constitution to do the things that would infringe upon the rights that are listed in the Bill of Rights. Why did that not give the Anti-Federalists comfort?
Yeah, so that is true that one of the Federalist responses was, why would you be worried that Congress will make such and such a law that may violate your rights? Since shouldn't you be offered solace by the fact that Article 1, Section 8 offers only enumerated powers to Congress, and so they can't possibly do the thing already that you're worried about. And I think one of the reasons that the Anti-Federalists worried, nonetheless, was they expected to see them written down anyway. It was almost like a political theoretical norm of the time, given the fact that they had always been written down. At least the theory goes, at least since Magna Carta,
right? Which was hundreds of years before,
exactly,
so
1215.
Yeah,
and so we expect to see them written down. Our states write them down. Why are you afraid of writing them down? Was sort of the way the rhetoric would go. Patrick Henry, quite famously, had said, on the floor of the Virginia ratification debate, "Are you worried that it would take too much paper?" As if that was the thing that was really.
He was always so gentle in the way he phrased things.
Yeah, he was quite an orator. So I think that's one reason. But the other one, I think, is that there is a certain discipline in committing yourself to a text, and that's something we see today. It's true of all lawmaking, and I think that was the thing truly driving the Anti-Federalist desire to have it written down.
So, what was the? You've read a whole lot more of the Anti-Federalist Papers than I have. The ones that I've read, one of their main objections was to the executive branch. Why did they fear the executive branch, and what did they have to say about the problems with the way it was set up in the Constitution?
Yeah, it's true. They had if you try to organize them by theme, they do have some of the same structure as the Anti-Federalists, where they'll sort of go clause by clause. I'm sorry, of the Federalist Papers.
Sure.
They go clause by clause through the Constitution, and they say, well, now let's think about Article 2, Section 1 that vests the executive power in the President of the United States. And then they would have another series that would talk about other ones. But you're right that some of their most powerful criticisms were about the executive power. I think underlying it, if you read enough of the Anti-Federalists and enough of the commentary on what they were saying, is at the time, in the late 18th century, the thing that united the American people, despite Federalist and Anti-Federalist differences, despite differences in location and despite differences in income and socioeconomic status and all the rest of it, one of the things that was common across the political thought of the various factions was a fear of the English monarch. It was the thoughts of the American Revolution were front and center in the American mind. And so the natural place to look in fear would be the executive power, right? The thing that if you're still thinking about stamp taxes and abuses of enforcement, and you would tend to look at the things the king did would be the things that you would naturally be fearful of seeing in Article 2.
Right.
So that was one reason I think that was kind of motivating their fixation on Article 2. But the other, and this goes to a broader kind of concern that they had about the entire constitutional framework that came out of the Constitutional Convention in Philadelphia, is they thought, well, okay, we're going to create a new federal government. We understand that there's going to be representative branches in Congress. Mm-hmm. We have a whole slew of concerns about the courts, the new federal courts you're going to create. But one thing that's obvious by looking at this is it's going to take a lot of executive power to make this whole thing work. You can't just have people in Congress making laws and courts interpreting them. You have to have people to enforce the law.
Right.
And when we look at Article 2, you don't see the same sort of, for example, textual, structural limitations that you do in Article 1. Article 1, Section 8 very specifically says, here are the enumerated things that Congress does. And you don't necessarily see that in Article 2, the Anti-Federalist concern went.
Okay. The word itself, the Federalist itself, we hear it thrown around a little bit now, but I don't think very many people really know what the word means. I mean, we hear Federalist Papers, but why were they called the Federalist Papers and the Anti-Federalist Papers? Yeah,
it's interesting. Some Anti-Federalist scholars, Herbert Storing being the most prolific, have suggested that maybe these terms are more confusing than they are elucidating, that maybe a better way of thinking about it is nationalist and federalist. That is at least the way we understand federalism today, where where the national government and the state governments have some, and we can debate where the lines are, but some spheres of sovereignty that overlap in some ways, or separate in other ways, are subordinate, the states being subordinate to the national government ultimately. But if you believe generally in states and their ability to either pass laws or differentiate themselves from one another, that's what we understand in modern federalism to be captured in that term. Mm-hmm. Whereas really the thing that Hamilton principally, but also Jay and Madison were arguing about was the need for a new national government, or general government is the way they would refer to it in the 18th century. So when they say Federalist, what they really mean is the new federal government or the new national government. Throughout the Federalist Papers, they refer to it as the general government.
Right. So Justice Scalia, he was famous among lawyers who follow Supreme Court things, at least, for he would write like 1 or 2 line dissents saying everything about the majority opinion's fine, but you cited legislative history and you should never do that. Aren't the Federalist and Anti-Federalist Papers the sort of the constitutional equivalent of legislative history?
That's a great question, and this is a very well taken criticism of both of them. One of my professors in law school, John Manning, had written many years ago that these are worse, arguably, because they're propaganda. They're written mm-hmm. they're written in newspapers. It's like crediting a newspaper editorial. Right.
Sure.
But it's even worse than that because they're anonymous propaganda, right? They don't even know. They're all signed by pseudonyms,
Right.
And with a couple of exceptions, you don't even know who's actually making the argument. So why should we take any of this seriously? Obviously, people take the Federalist Papers
very seriously.
Very seriously.
Right.
They are cited regularly, notwithstanding the criticism of anonymous propaganda. And I've used that as kind of a jumping off point to understand why I think the Anti-Federalist Papers matter anyway.
Right.
So one reason I think that you should care one way or the other is that if you take as a matter of principle or a matter of just a granted proposition that the Federalist Papers should be studied and read and cared about, well, then it makes a ton of sense to also read the Anti-Federalist. One reason is that the Anti-Federalists come first, and most of the Federalist Papers are written in response. If you ever read the Federalist carefully, Hamilton and Jay and Madison will often say, "It has been said such and such and so and so," or "Our learned brethren have argued such and such and so and so." And if you're like me, you just sort of glance over. When I was in law school, you just glance over that, and you figure that they're responding to somebody, but you don't care to pause for a moment and wonder who they are.
Right.
But the people that they're responding to are the Anti-Federalists, and Herbert Storing, again in his fantastic compendium of the papers, points out where Federalist number X is responding to Brutus number Y, and so if you care about the Federalist, which a lot of people do, the Supreme Court cites them. They are, largely they are important and influential for whatever reason you in your own mind might find them influential. Mm-hmm. I think you do yourself a disservice to ignore the thing to which they're responding. The way I explain it when I go around and visit law schools is I say, it would be an absolute abdication of judicial responsibility to decide a case by reading only one brief.
Right.
And I would never do that, and I would hope no judge would ever do that. And I think the same could be said for reading these two things. Regardless of what weight you put on the Federalist, whatever that is, it should be at least commensurate to the weight you put on the Anti-Federalist.
It's something I've never on this podcast, but I've told several times. When I did a district clerkship, the trial court, and a motion would come in, and it would be my job to read it, research it, and then come to the judge with a recommendation. The first time I did that, I read the motion and I thought, well, I'm done. This is obviously we have to grant this motion. But, I say we have to grant. I didn't grant anything. But it has to be granted. It's obvious. I've read the motion. And then I thought, I'm still new. Let's just go ahead and read the response. And then I read the response. And I thought, well, there's no way you can grant this motion. And It's really easy to make your case when there's nobody as your adversary.
Exactly right.
Until I started thinking about the Anti-Federalist Papers, it never occurred to me to read the opposing briefs. I'm making air quotes. But So, did any of the writers that we know wrote Anti-Federalist Papers, did they end up getting persuaded to vote for ratification in their state conventions?
Oh, yeah, that's a very interesting question. I have not gone back to cross-reference those. There were some of the Anti-Federalist authors who ended up being, who were at the Constitutional Convention.
Right. I think Elbridge Gerry was.
Gerry was there. George Mason was there. I'm trying to think the two from New York who left Alexander Hamilton, Lansing and Yates.
Right.
They were at the convention at the beginning. They left sometime in the summer, around the beginning of July, if memory serves. And we at least think that Yates and maybe Lansing, but definitely Yates went on to write Anti-Federalist essays. But I don't know when they actually sat down to deliberate over them whether they voted for ratification. One of the things I have heard when I have gone around to talk about the Anti-Federalists, and a question I've gotten in particular from law professors, is, why are we talking about, and this goes back to the question about legislative history, why are we talking about the stuff that was, written in 1787 and 1788? Mm-hmm. Why aren't we talking about the ratification debates and what was going on in the ratification votes? And I don't mean to suggest that that's not relevant. It certainly is.
Sure.
There was a lot said in those debates, and if you read Eliot's compendium of them, it's incredibly elucidating sometimes. But one thing I think that is particularly telling about the debates themselves is that there was an entirely separate question going on in the ratification debates, which was depending on what side you were on, the race to 9 or the fear of 9, right? So at 9 states, the Constitution was going to be ratified, and a lot of what was informing the debating, the position taking, and perhaps even the voting is, do we want to be state 8? Do we want to be state 9? Heaven forbid, are we state 10? And if you read the newspapers, and there's a fantastic graphic, if we were doing this on video, that I could show you of this. It's a political cartoon or illustration. I'm not sure you call it a cartoon. It's a series of columns with the states' names on them, or states' abbreviations on them, falling over. And which column was going to be the one that was the last to tip. The ninth one.
Sure.
Yeah, exactly. And when the ratifiers met in Virginia, for example, they didn't know that the ninth state had already ratified. That it ratified in the middle of the Virginia ratification debate. And
there wasn't exactly a tweet to announce it at the time.
Exactly. And news moved more slowly. And so, again, I don't mean in any way suggest that what was going on in the ratification debates and the votes are irrelevant. I just mean that it's a little bit more complicated than just a straight-up explanation of what do I think about Article 2, Section 1 of the proposed Constitution.
Right. Why did they write under both Federalist and Anti-Federalist? Why didn't they write under their real names?
It's really interesting. I've read Storing, and he has theories about why they chose the pseudonyms they chose. Mm-hmm. But I'm not sure if there's a really good explanation, other than it was just convention, that it was a way that it was accepted, and no one thought it was odd or weird to have it signed Publius. I'm not sure I have a really good explanation. Some of the Anti-Federalists didn't. Mason, one of my favorite quotes from Mason, was a vehement opponent of slavery, and one of the leading Anti-Federalist arguments against the institution of slavery, inveighed against it in the strongest terms, referred to slave owners as petty tyrants and all manner of things, and did it in his own name.
Right.
You didn't rely on some pseudonym. It wasn't as if he was worried about if he wasn't worried enough about the backlash to use a pseudonym to hide himself. Obviously, Patrick Henry, he did it in his own name. Mm-hmm. He was a vehement opponent and made his arguments known. And then others chose otherwise. So,
you mentioned Hamilton and the two from New York who left the convention. I believe it's a New York. It's an NYU law. I forget which publication it is, but you wrote a piece about the Anti-Federalist Papers that talks about how the Constitution is signed and New York is different than the other 12. Yeah. Tell us about that and what it means, if we know what it means.
Yeah, it's very interesting. So by way of background, around the beginning of July, somewhere between the end of June and July 5th, 2 of the 3 commissioners or delegates to the Constitutional Convention from New York left. And so when the way that this worked in the 1780s is the states would authorize with commissions, formal sheets of parchment that would say, I, Governor Clinton, and the legislature of New York hereby deputize the following 3 individuals, Alexander Hamilton, John Lansing, and Robert Yates, Esquires, to serve as our delegates, as our representatives, as our commissioners, to go down, as our deputies, to go down to Philadelphia and to meet and debate over this topic. So it looked a lot sort of like a judicial commission, a piece of paper explaining what you were supposed to do, how you were supposed to do it. And brilliantly, the commissions from these various states are collected in the appendix of Farron's and Farron's records of the Constitutional Convention. You can actually read them. And in that law review article you mentioned, I quote some of them because they're really interesting. They're all different. Each state had a slightly, some states sent 3, some states sent fewer, some states sent more. Delaware is one of my, I think, the most interesting ones because in the Delaware commissions, the delegates are specifically told what they're allowed to vote on and what they're not allowed to vote on. There was a provision in the Articles of Confederation that protected small states, and they're specifically told not to, get rid of that or vote on that, that their commission falls short of that. Anyway, and one of the great questions when the delegates met in Philadelphia at the beginning of the convention was, what are we going to do with the then governing document, the Articles of Confederation, that required unanimous consent of all states to amend it? And the New York delegates, 2 of them anyway, Yates and Lansing, were upset about the fact that and we know this because they wrote a letter to Governor Clinton when they left. Okay, that's collected in the Herbert Storing's compendium of Anti-Federalist writing. So we know their reasons for leaving. They were worried that the various delegates and commissioners were exceeding the powers of the states that sent them. Remember, under the Articles of Confederation, we didn't have we the people. As Patrick Henry said it, we had we the states, and the states were the sovereign. And so the states were the ones sending them, and the Lansing and Yates worried that the folks with the commissions were acting in excess of their power. And so they worried that what was going on was not authorized by the consenting states, and so they left. And they left Hamilton there all by himself for most of the summer.
Do we know why Hamilton didn't leave? Did obviously he wrote a lot. Did he say, well, you guys think that we're exceeding our authority, but I think X? Do we know what X would be?
Yeah, Hamilton was, and his views later certainly corroborated, believed very deeply in the need for a new, strong general government. It's easy to sometimes forget the exigencies of the time because there was a huge concern about the lack of a national or general government and its ability to provide defense to the then young nation. They had problems with debt. They had problems with economic discrimination between states and ports. So, states that had big ports that were incredibly wealthy and economically powerful would discriminate against other states that would need the ports for their commerce, whether it was agriculture or whatever. And there was a strain of thought, a strain of Federalist thought, and Alexander Hamilton is perhaps the greatest example of this, that thought we need a new, strong government, that the reason that the Articles of Confederation are not sufficient, he would argue, is because we don't have enough strength and vigor, as he put it, in the general government to provide for these, or to remedy these problems, whether it's economic discrimination or the common defense or the debts that were associated with having fought the Revolutionary War. And so he was a big believer in the need for a new government.
So did he agree that they were exceeding what the authority that the commission had given them, and just said, well, maybe so, but we'll worry about that later? Or did he think that they were not exceeding their commission?
So this actually there is a Federalist paper on it. I apologize, I don't have it in front of me to remember. He actually talks about this.
I did not know that. I've read them, but it's been a while.
Yeah, I've read them, and I'm not as good with my numbers on them as I should be. But yes, he says, look, the commission says we're supposed to address the exigencies of the situation. We're addressing them.
Right.
And, as to, this argument, this sort of legalistic argument about whether it's in excess or not, the demands of the times call for the demands of the measure. And so he actually, and I can't remember if it's Hamilton who writes this one. I'm pretty sure, but I have to get back to you on who wrote it and the number. But yes, he actually does address it.
So wouldn't that in itself cause the Anti-Federalists to say, look, the thing that we're worried about is that you're going to exceed the powers that are written down in this proposed Constitution, and as evidence that our worries are well-founded, look at what you're doing with the commissions that you were sent to this Constitutional Convention for. Did the Anti-Federalists explicitly cite that as here, look, you guys, you're already setting a precedent of overstepping the bounds that we put on you?
I think that there was a strain of anti-federalist thought that said exactly that. This was one of the biggest. It seems quaint now, almost quaint, I suppose, in hindsight, because "we the people" is such a celebrated phrase, and rightly so, because the Constitution has been so successful as an instrument of self-government. And the preamble of it is incredibly powerful language. But it was one of the things that, and I think I mentioned this earlier, that Patrick Henry mentioned specifically in his debate. He said, "We the people." Who is this "we the people"? Right? It should be "we the states."
Yeah.
And it was his argument. And you guys have, and you people, I should say, in framing this new document and proposing it for ratification, have completely abandoned the tether that the old government had, and without authorization to do so, and he did it in exactly those terms. So when we look back on hindsight, especially after the people ratified it and after the hundreds of years of success that the nation has had under the document, and it's almost difficult to understand why this argument would have such purchase at the time, or why he would even bother making it.
One of the things, and this kind of goes to the argument that you're citing that Patrick Henry made, and in your NYU Journal of Law and Liberty piece that we referenced just a minute ago, you said they also worried the new federal government would, quote, hollow out or melt down the states, and that all government power would be centralized in the national seat. First of all, I think we've kind of covered why they thought that, but what did the proponents of the Constitution, the Federalist Papers, what did they say to kind of calm that fear that no, we're not going to hollow out or melt down the states. Mm-hmm. We're going to, do something besides we're going to keep the vibrancy of the states.
Yeah. So this was a chief argument from Brutus, and he worried about it in all sorts of different ways about what the fonts of legislative power in Article 1, Section 8 would do, the necessary and proper clause would do, the new Article 3 and the federal courts would do to sort of hollow out, those are his words, the states. And the principal response from the Federalist was twofold. One, we admit we need stronger general government. We need vigor. Again, the Federalist word. We need vigor in the general government, and this is what we're trying to do. So in some sense, they say, okay, we agree that we are creating a new, stronger general government. So that's fine. But we disagree that we're, quote unquote, hollow out the states. And the Federalists have several responses to this argument, not the least of which is we're going to have very few of these federal officials around the people, so that when people think of their government, the people that this is the way the Federalists would explain it, they will naturally think of their state government, because that's going to be the one in their town. That's going to be the judge that is in the courthouse, or that's going to be the magistrate who's responsible for whether it's a judicial function or an executive function. Those will be state officers, not federal officers. They will be the ones, to quote the Federalists, that draw on the hearts of the people. The people will naturally have affection, is another way that the Federalists would describe it, for their state government, for their state officials. And so if, even assuming you're right, Brutus, the argument will go, that we're creating this sort of competitive state versus federal, the state will be the powerful one. So you have nothing to worry about.
The Brutus 1, I think, uses the phrase talking about the powers of the federal government were great and uncontrollable. Mm-hmm. On those of us who are kind of on the right side, and I don't mean right as in correct, but right as opposed to left, of the political spectrum, we look at the Constitution and we say, no, they're not great and uncontrollable. They're enumerated and they're limited. I think if whoever wrote Brutus 1 were around today, he would probably be arguing that the federal government doesn't have great and or shouldn't have great and uncontrollable powers. But in terms of figuring out what the Constitution means, what the words mean, didn't Brutus give a pretty powerful weapon to those today who want a very, very powerful federal government when he said, look, the language of this, I mean, these are not his words, but basically the language of the Constitution gives great and uncontrollable powers to the federal government. If I'm on the political left now, I think I'd look at that and say, look, see, this is what the terms mean. It's a great and uncontrollable. We can do anything we want, pretty much. And if you don't believe me, read Brutus 1. He didn't like it, but we won. We got it ratified. How would that argument be refuted, if it can be?
Well, I certainly have no comment on current affairs or
Sure.
the way that would play out in the sort of current environment. But I think at the time it's very hard to understand what Brutus is saying without also reading it with response to what the Federalists had to say. The Federalist response to Brutus's argument, because the Federalist response is, again, to admit, yes, we do need general power or power in the general government, but Brutus, the argument goes, the thing you're missing is that ambition is going to check ambition, in Madison's words, right? It's maybe there will be power, but it's going to be control. And maybe you could even say that there will be a lot of power in one branch or another. But if we have them balanced against each other and separated, the Federalist argument went, they will separate that. They will check the separation of powers will check one another and keep everything in balance. And that has been an idea, if you want to talk about ideas that have won out over the day and that have prevailed over the centuries, the separation of powers, the checks and balances, that great protection of whether it's the structural powers of government or individual liberty, that has prevailed over the centuries. Justice Scalia was famous of saying, who cares about the Bill of Rights? Justice Scalia argued those are just parchment barriers. What really matters is the separation of powers. That's the thing that actually is what controls it. And Brutus, I think, ends up in his later papers having to deal with the separation of powers argument. And his response is not so much that, no, the powers are great and uncontrollable and so great and uncontrollable that they can't be checked and balanced. His argument is to actually fight it on the merits and to say, well, now maybe I'm more concerned about, well, do we have sufficient separation of powers? And so he actually he quibbles with bits and pieces of how the powers are separated. So, for example, the president's appointment power is checked by advice and consent in the Senate, or the vice president is obviously an executive officer, but is the president of the Senate. So Brutus then actually has to engage on that ground much more so than the powers are great and uncontrolled.
So I think this was before we started recording, but you mentioned that Storing said that one of the problems with the labels, Federalist versus Anti-Federalist, it implies that the Anti-Federalists, they were just against the Constitution as drafted. But you said, no, they actually had a positive agenda, which is a little more of a political buzzword than I'd like to use. But there was something they were actually for. They weren't just against the Constitution. What were they for? And I'm sure they weren't necessarily all lined up lockstep in the same thing, but generally, what did they want to do about the Articles of Confederation? Yes,
that's a great question. So, Volume 1 of Herbert Storing's magisterial work is called "What the Anti-Federalists Were For," and he points out that there was an incredible body of political thought and cogency behind their affirmative philosophy. It was not just that they were opposed to the new document. They actually supported an idea, and it was admittedly a little inconsistent, or in tension at least anyway, with some of the things that the Federalists were trying to accomplish. And that's how we end up with this dichotomy of nomenclature. But in some ways, the dichotomy of nomenclature obscures how much they actually agreed upon. And one of the things that the Anti-Federalists really believed in was they believed in local life. They believed in having power decentralized. They believed in having communities that were largely self-governing. And so one of the things that they worried about was, and again, they didn't have Twitter, they didn't have the Acela, they didn't have, obviously, airplanes. So they were worried if you take a bunch of power and you move it outside of our local community so that, our school or our church or our family or whatever institutions there are in our local communities, and you move them to the national seat, that it's away from the people. They have lost control over their institution, over whatever power has been taken out. And the Anti-Federalist argument would go, it doesn't matter if it's a little or a lot. Whatever the quantum of power that leaves is necessarily taking it away from the people, right? That the great little r Republican principle of government that is of the people, by the people, and for the people, and you have removed it from them. And when you do that, people become disaffected with their government, right? Because they feel like they can't influence it. They don't know. They don't have the same relationships with their lawmakers or their law executors or their law interpreters that they otherwise would have had. And as they grow disaffected, they become increasingly alienated from it, which only creates this cycle. The Anti-Federalist theory was of disintegration, and that is unhealthy for the polity. That was a very different idea, a very different political philosophy than what was motivating the Federalist.
A lot of the Anti-Federalists, the ones that we know wrote the Anti-Federalist Papers, and of course just others who we know opposed the ratification, they ended up serving in very high places. Vice president. I don't know if any of them became president, but they certainly didn't say, "Well, I'm not even going to participate." When they did that, did they view their efforts in opposing the Constitution as a total loss because it was ratified, a total win because, well, it was ratified, but we got we got a Bill of Rights and we got some assurances and things of that nature, something in between? How did they view things after the Constitution was actually ratified?
Yeah, that also a great question. There's not a ton of them who went on to national office. Gary is a very obvious example, but in many ways he's an exception that proves a rule. I do think that if some of the post-founding Anti-Federalist writing, so for example, Marcy, Otis, Warren is a good example, was a little sorrowful, maybe slightly overstating it, but regretful of having lost the ratification battle. So one of the things that I have confronted throughout my study of these papers and talking to people about it, and people who know much more about it than I do even, is this idea that the Anti-Federalists don't matter because they lost. And I reject the premise because it's not obvious to me. I mean, they obviously lost one piece of it.
Sure.
They prevailed on others. And even for the parts that they quote unquote, and I'm doing the air quotes, lost, they still remain relevant for the discussion. And I think that's true of their their own writing at the time after the founding, after the ratification. I think that they still remain in their enduring relevance even in the early 18th century. I'm sorry, early 19th century.
Sure. What did they say about Brutus I had some comments about the Electoral College that I found surprising. What did he have to say, and were there any fixes or changes to how the president is elected based upon what the Anti-Federalists objected to?
Yeah, this is interesting because we still talk about the Electoral College today. But we don't talk about it in the way that Brutus and the other Anti-Federalists were concerned about. And again, this is one of the things where you read it now and you think, "What? Goodness gracious! This seems so anachronistic or weird or ill-founded." So here was basically his concern. He thought if you intermediate between the voter and the president, the elector, right? You put the elector in the middle between them.
Right.
What's going to happen is the president is not going to campaign directly to the people, but is instead going to lobby or campaign or politic to the elector. And isn't that going to be terrible, he thought. And so now, obviously, we don't see that, right? And I don't know if there's been I haven't gone back to study the early 19th century, if there's ever been a time in American history where that was true, where a presidential candidate, instead of doing a town hall in Iowa or whatever is going on the campaign trail, would instead just go directly to the electors and try to convince them directly, as opposed to the people and the voters more generally. But certainly not true today. And a lot of the things that are interesting about the Electoral College today, and obviously there's plenty of current event debates about it, but that's not one of them.
Right. Mercy Otis Warren, well, I think she, and also in Brutus 1, one of the things they were worried about is what I think they referred to as a permanent aristocracy. Now in political debates, we talk about the bureaucracy, but I don't think we think of them as we think of them as bureaucrats, perhaps, and whether you like that or not is a totally different issue. We don't think of them as an aristocracy. Why did they use the term aristocracy, and why did they fear that it would be that this executive branch would result in a permanent aristocracy?
Yeah, so the concept of bureaucracy did not even exist, as far as I can recall at the time. Is an idea that came in later political thought in the notions of bureaucracy. But at the time, in the late 18th century, the notion of aristocracy was quite prevalent, and what they meant by that was simply a permanent ruling class, a class that wouldn't rotate out or be accountable. But they would just rule as a matter of right in perpetuity. And there were a lot of different strains to their concerns about aristocracy. One of the ones that I've always found the most interesting is the Society of the Cincinnati. If you've ever studied this, or I'm sure some of your listeners have heard about it, this is another topic that I had not really studied before I opened the Anti-Federalists. But the Society of the Cincinnati was a venerated veterans organization. In fact, it may have been the first veterans organization in United States history, because it was founded in the encampments of Washington's army in the Revolutionary War. Wow. And the Society of the Cincinnati was it was sort of a who's who of the political elite in the late 18th century. I'm forgetting the statistics, but of the 55 people that met in Philadelphia to frame the documents, like 23 or some odd of them were members of this society. And the Society of the Cincinnati had a meeting hall in Philadelphia. So George Washington would preside over, he was the president of the Constitutional Convention. He'd preside over the convention. He'd take breaks at lunch and go over to the Society of the Cincinnati. And so you think, well, what does this have to do with aristocracy, and why does this matter? Well, a couple things. One, all of this was done in secret, which is another thing that Anti-Federalists did not like. They didn't like the fact that the Constitutional Convention was done in secret. They didn't like the what they viewed as the secrecy of the Society of the Cincinnati. But perhaps more importantly is that membership in the Society of the Cincinnati descended by hereditary right. So the original members were veterans in Washington's army, and then it descended to their heirs hereditarily. It had a flair of aristocratic norm to it, and it just so happened that the members of this society were incredibly politically influential. And so the concern that was launched by many of them, Mercy, you're totally right, Mercy Otis Warren was one of them, is what we're setting ourselves up, where we've got these sort of secret meetings and hereditary passages of power and these elite institutions that are cut off from the people, is we're going to have this a ruling class that isn't accessible to we the people, to the norms of Republican government, little r Republican government.
Right. It's amazing to think. I think the general public is so, and I until very recently, I was vaguely aware that there were Anti-Federalist Papers, but so much of the preservation of freedom that actually the Constitution has achieved. We're a couple hundred years plus into this experiment of a federal government with states and all of the freedoms that we still enjoy today, it's hard to imagine and impossible to prove what it would have looked like had the Anti-Federalists not demanded certain things that they got, like the Bill of Rights. Is there any way other than just rank speculation to imagine how things might have went absent the Anti-Federalists?
Oh, if there is, I certainly can't do it. Certainly above my pay grade. I suppose you'd have to be a first-rate political theorist or historian or counterfactual narrative teller. I have no idea. But it is interesting that some of the things that the Anti-Federalists argued that they argued about they had foretelling of the future. You know, they predicted the way certain things were going to go with the new Constitution. And, I'm sure some of those were right. Maybe others were wrong. I'm certainly not equipped to judge that one way or the other. But one of the ones that I think is telling is that there was an enormous strain of Anti-Federalist thought that was virulently anti-slavery and that criticized the Constitution for its the compromises. The 1808 clause is one of the ones that came out for particular Anti-Federalist scrutiny. The one that allowed prohibited I suppose it prohibited Congress from regulating the slave trade until 1808.
Right.
For particular Anti-Federalist scrutiny, and one of the passages that I believe it was Mason in his own name talked about was this is setting us up for violent conflict. I mean, he all but predicted the Civil War.
Wow.
And because of his fierce opposition to the way that the Constitution embraced that, and I don't mean to suggest at all that there weren't anti-slavery advocates in the Federalist
Hamilton
camp.
was famously so.
Of course. But one of the things that the Anti-Federalists did argue was we shouldn't compromise on the topic. And obviously the whole Constitution is embraced, the original Constitution has that compromise in it, and the Anti-Federalists were fiercely against it, at least some of them.
And just as I was asking the question, a couple of things came to mind. I believe I might get the act wrong, but I think the Alien and Sedition Act was struck down by the Supreme Court as a violation of the First Amendment. Again, it's discussing the counterfactual, but absent the First Amendment, that would have been at least a much taller hill to climb to get that invalidated as unconstitutional. And it's, of course, one of the most precious freedoms we have now that so many other countries, they don't enjoy the right to fiercely criticize their government. And absent what the Anti-Federalists did, that may be a totally different world. Maybe not, but it's interesting to think the debt that we owe both the Federalists and the Anti-Federalists, but we forget what we owe the Anti-Federalists for preserving and ensuring the freedoms we have still today.
Yeah, and I mean, obviously there were a lot of forces that came into play in framing both the Constitution itself and the various amendments to it. One of the things that I think is particularly important about thinking about why the Anti-Federalists matter, why we're even doing this podcast or reading their papers or taking them seriously, is that they were rich in political thought, and they had, whether those are good or bad, and whether they were right or wrong, or whether they succeeded in this or lost that or framed this or this provision of the Constitution or opposed it, understanding what the document was in 1789 and what it is today and why it is the way it is, I think requires some ability and some effort to understand genuinely what was happening. For people who care about the original public meaning of the document, you have to understand the environment in which it was debated and framed, what those words meant to the educated reader existing in the late 18th century. And the Anti-Federalists were an essential part of that. I mean, in many ways, they were more important than just the person on the street because they were contributing to the debate.
Sure.
Corpus linguistics is a big topic now, and people are talking all about various sources of meaning and how do we understand what these words meant. And the Anti-Federalists were contributing to those words at the time.
Well, thank you so much for your work on this and for taking your time to discuss it with me here today. And for the Personal Responsibility Lawyer podcast and Lovins Trosclair, I'm Michael Lovins, and we'll see you all next time. Thank you for listening to the Personal Responsibility Lawyer podcast. If you like what you've heard or if you've learned something interesting, please do me a favor and rate the show on iTunes. It really does help. You can get more information about this show, including the show notes, at my personal website, michaellovins.com. And now I have to do some disclaimers where I say stuff that you already knew, but I got to say it anyway so that I keep the state bar happy. This podcast is not legal advice. You listening to this podcast does not make me your lawyer or you my client. Neither does it make any of my guests your lawyer. If you want me to be your lawyer, contact my office. If I can represent you, we will execute a written contract stating the specific terms under which I agree to represent you. Did you really need me to tell you that? I really, really hope not. Also, I am not certified by the Texas Board of Legal Specialization as a personal responsibility lawyer because they don't know what that is. They also have not certified me in any other areas of specialty that they actually do recognize. I think that does it for disclaimers. For Lovins Trosclair and the Personal Responsibility Lawyer podcast, I am Michael Lovins. We'll see you next time.